All right, so welcome to our third session in our track on Gen AI, music, and the arts. And this talk is going to be legal issues with Gen AI in art and music. We have Fred Wilf and Louis Sorokin, pronounced. I'll be the moderator, if you don't know me, Rebecca Mercuri. And we also have another team member from your law firm, Josh Waterston. And all three of them are what is known in Philadelphia fondly as Philadelphia lawyers. Sometimes people consider that derogatory, but they have a great firm in Philadelphia. I think you've been practicing in and around Philadelphia your whole career. And I'm originally a Philadelphian, so I came up with the idea of having this as a panel session because you've spoken at many TCFs, absolutely, on a variety, and also IT professional conferences over the years. But we wanted this to be focused on a lot of these issues that are arising around the AI concept. So I guess we'll just start. We're going to start with introductions, just sort of going through each person. Oh, so then the first one is me. So you can read all this bio stuff there. It's also on my website. But basically, I spent 2 decades going to various colleges and earning 5 degrees, and then went off to Harvard and got an honorary degree from Harvard for being a fellow of the Radcliffe Institute. It's actually Radcliffe. And but these degrees combine all of these interests. So my PhD is in computer science from the engineering school of the University of Pennsylvania, as is my master's in engineering. But I also have a master's in computer science from Drexel University and a bachelor of science from the other Penn State. And also, at the same time I was going to Penn State, I was also attending the university, what's now the University of the Arts. It had different names back then. That degree was in classical guitar. I was actually also going for a music ed degree, but that would have taken another year. So I missed out on that one. So I have gone through all of these various different trends in technology. A lot of my studies at the university started in the 1970s. Now I should say that my father was a science teacher in the Philadelphia School District for 41.5 years. And so, and my mother was an English professor at Drexel University. And the combination of the arts, they both were very much into the arts and also into the sciences, that really influenced not only me, but also my brother and sister. And so our careers were always a conglomeration of these types of things. Very involved in audio engineering. My brother had an audio engineering business in addition to his day job as an electrical and computer engineer. So again, it gives you an idea of what was going on in the family. So we were always very interested in all of these types of things, but it was also especially the application of the technology that is really the running thread through all of my work. Eventually, I was teaching for a while. But I decided that I want to start my own business, which is Notable Software. We do digital forensics. The Notable was really a note. We were originally doing computer software for schools, just educational music software. So, and that was on the early Apple IIs. So we were an Apple certified developer, stuff like that. So that was how I really started out doing that type of thing on my own. But I also spent some years at RCA Laboratories in Princeton, and also at AT&T Bell Labs in Homedale. So, but my mind has always been that sort of mixture of all of these things. And along the way, I've gotten to meet some of the really amazing people in early computer music in the 80s and going forward. So, you know, it was just a really great opportunity for me. And I've landed now into the world of AI. So that basically brings us up to the present. So we'll see what we're going to be doing with that. Most of my work is just enjoyment and, you know, playing, performing, that type of thing. So I'm not really doing any type of work in that area, but it does come up occasionally in some of my digital forensics work, which is basically what Notable Software has been doing full time for the last 20 years. So basically I work in the law, but as a forensics expert. So that's it about me. We can move on. And who is up next? Fred, you're going to be up next.
My time was on the over the confession, but long story short, I've been practicing law since '85. I was a computer programmer for about 5 minutes to help pay for college, but I've been doing technology on the art side. I'm an amateur photographer, and I've been working with the Volunteer Lawyers for the Arts, which is a lawyers group that assists artists. This particular group is based in Philly. Other cities also have similar groups, including New York and Washington D.C. But I've been working with artists as well throughout my career. Right now we have a small company called Wilftek. It's based in the Philly suburbs. Including, the next slide, we have Lewis.
We have Lewis.
I can understand only because I can't see the entire audience because I'm that short.
I'm thinking the same thing. The more I sit behind this monitor, the less I think anybody can see me. And maybe that's a good thing. Maybe that takes some of the pressure off. But good afternoon, everybody. My name is Louis Sorokin. I work with Fred at Wilftek, working with tech companies and non-tech companies to help them integrate tech into their businesses and navigate into legal issues that come up from a business side, intellectual property side, and more these days that includes AI. I also have a background in music, not nearly as impressive as Rebecca. However, I grew up playing French horn, piano, guitar, smattering of other instruments, minored in music at Franklin Marshall College, where I majored in cognitive science, which is a nice tie back to all of this AI stuff we have going on. So that all being said, these days I love to find the intersection between technology, the arts, music, and the law. I've written a few articles for some legal as well as music industry publications about these issues. About a year ago, a few weeks before the fake Drake news headlines, which we'll talk about later this afternoon, I wrote a piece predicting exactly that issue that ended up in Hypebot, fairly well-known music industry blog. So that is all to say that these issues excite me, and I'm excited to be here today with all of you.
Wonderful. So we decided we're going to do this as like a panel session, and I'll pitch out these different topics that we have. We also have slides to go along with some of them, and we'll each like opine on these things, except I'm not doing any opining. I'm just going to help navigate through the stuff that you're going to talk about. But I wanted to start out, and we all sort of conferred on, what these topics were going to be. So this is not just impromptu. So we'll start out with, how does the use of GenAI to create music or art pose problems in getting and enforcing copyright? You can just imagine all of the different problems. And you've sort of heard that, those of you who are here for the first two talks, you were hearing some of these problems. But let's, why don't we start with you?
Sure. Probably go to we have attached over next, perhaps. Already have the dog.
We have that a little bit later.
We have copyright first. One of the problems you're dealing with copyright law. Copyright law goes back to Gutenberg. The idea that suddenly with this newfangled machine from Gutenberg, you can actually make a book in less than a year, or something you can even do 1 or 2 books in a couple of weeks. Since then, copyright has been expanded beyond books to include artwork, architecture, two-dimensional art, three-dimensional art, a few other things. In the US, a copyright protects anything that is an original work. It has to be original work of authorship, fixed in any tangible medium of expression. And then the question becomes, well, if you're using AI as a tool to build something that you won't protect by copyright, is that going to be protected? And we've been running into a lot of issues with that, not the least of which is that the Copyright Office is not buying any of it. So they come out with a couple of policies, and we'll get into some of the underlying facts behind it, saying, and as far as the Copyright Office is concerned, if you're using AI, anything created by that AI is not going to be protectable by copyright, because it's not considered human authorship. Even though most of what an AI does, especially using a large language model, but using other variations of AI as well, is based essentially on what humans have done. If you feed something that's created by a human into the large language model, and the AI eventually ingests that, processes that, and then is able to come back with something that maybe based primarily on what it's been taught. Sometimes it's very close to what's been taught, sometimes it's different. But the Copyright Office, being the Copyright Office, it's a federal government agency. They've decided that because what the AI outputs is not something created by a human, in its opinion, in the Copyright Office's opinion, anything created by AI is not going to be protectable by copyright law in the US. Some other countries that have copyright and IP offices have similar conclusions. The fact that AI responds to both the data in its model and to a human created prompt is not sufficient enough from the Copyright Office's perspective to get protection. So, actually, you want to talk about it a little bit?
Sure.
Yeah.
And so this is really just a little bit more on the human authorship piece. The Copyright Office has weighed in on this several times in the past before AI came into the picture. Some of the notable examples include a photographer who set up a camera in the jungle and a monkey ended up hitting the shutter on the camera and taking a selfie.
Yeah.
This monkey selfie ended up, the monkey name, I believe it was Naruto. So the case was filed on by PETA on behalf of Naruto the monkey.
Yeah.
Against the photographer who was claiming ownership, and the court ended up deciding that nobody owned this photo because there needed to be a human author, and because the monkey hit the shutter button, there was no author. There have been similar cases involving people saying that a book was not written by them, but rather by some holy divine intervention, certain other issues like that. So the courts are all fairly clear that you need a human author. And so that's where all of this AI authorship is really kind of coming down to. And that really leads us into one of the most notable examples is Zarya of the Dawn. And
So that gets us to the next question, which is, with respect to Gen AI art and music, how does the US copyright law and policy apply? What can be registered and what cannot? So
Absolutely.
Take it away.
And so that's a wonderful segue. So I want to say it was 2022, an artist named Chris Castanova used Midjourney to create images for a graphic novel called Zarya of the Dawn. The text was all created by Castanova. The images were the result of Midjourney's prompting, text-based prompts that output whatever would go into this graphic novel. And Castanova applied for copyright protection with the US Copyright Office, which is not a required step for having a copyright, but it is a required step if you want to be able to enforce those rights down the road. The application was denied because the Copyright Office determined that the images in the graphic novel were the creation of the AI and not Castanova. So that's really where they draw the line in the sand right now. There's some other examples involving training data that are a little bit more outside the scope of the question, but important as far as US copyright policy goes. There are lawsuits being filed right now and have been filed by by the New York Times, Publishing, Getty Images, and writer against OpenAI, Anthropic, Midjourney, Stability, all of the major AI companies alleging copyright infringement, because when you use any of these platforms, there is a large amount of copyrighted data that is in the training data, as many artists know, as many musicians know, and writers as well. So this is really one of the hot buttons right now, is where the book going to land when it comes to this question of, is training data acceptable to include copyrighted information, or do we need a license to that data? Now, the main argument in defense of the AI companies is something called fair use. I'll save you the legal nuances of it, but there are 4 factors: purpose and character of the use, which means how are they using it, the nature of the copyrighted work, the amount or substantiality of the portion used. So was it the whole work or was it a snippet of it? And the effect on the market or value of the work. So the courts weigh these factors and they decide ultimately whether the transformative use is enough to be its own creation, something that is new and outside of copyright protection. So the courts have decided in the past, for example, the Google Books was fair use, even though it digitized existing books. It was transformative and then it added the searchability feature. And so that digitization process was, although yes, a copying, it was still not copyright infringement. Yes.
How about the method of training the machine itself versus the output? So in other words, if you have software that you've developed that trains the machine, is that entitled to a copyright or a patent or both?
Wonderful question.
Sure. The software itself, as written by a human, is likely to be protectable by copyright under the current Copyright Office guidance. If the software had been written by an AI or used by an AI, the output of the AI from the software output created by the AI would not be acceptable to the Copyright Office currently. Now, we can criticize that for a whole bunch of reasons, but you're getting to the point of at what point does it matter that something is created by AI versus a human? When you go back far enough, you're going to find some human development, whether or not the AI builds on top of it or not. Good question.
So I write my own tools, software tools, since I'm a software engineer, to make my own art. That output is copyrightable, correct?
The software itself is protectable. The output, if you now, here's the interesting thing. Is your tool an AI tool or is your tool not?
It's just software.
Right now, it's just software.
Yeah, it encodes a particular idea that I call a design. And then the output is some ridiculously large number of patterns. And I have multiple, like hundreds of these things that I've written.
So I think that's going to be protectable.
That's one of the questions that we actually had. Was the use of technological tools. How do you demonstrate the artist's creative control over the work's expression? And what are the elements of authorship?
So the question that I'm getting at is if I write my own AI, right? Is the output of that AI copyrightable because I wrote the AI to do something specific, like generate images? So like maybe if I use something like Midjourney to make a work, it's not copyrightable, but maybe if I'm an employee of Midjourney, of one of their software engineers writing stuff.
What did you train it on?
Yeah,
I don't know.
Well, that's a good question. Well, have you met a gentleman named Stephen Thaler? Let us introduce you to Mr. Thaler.
I don't know if
have to speak on
Taylor.
We have slides right here. We have a slide on Thaler.
Yes, Mr. Thaler's slide.
So Mr. Thaler has written software that he calls DABUS, I believe, DABUS. So it's right here on this slide. Device for the autonomous bootstrapping of unified sentience. A retronym if I ever heard one. That's great. But it was the same kind of idea, which is he wrote his software that he calls DABUS, and then DABUS has created new things. And then Thaler has filed applications both with the patent office, it's technically U.S. Patent and Trademark Office. On the patent side, he's applied for patents. He's also filed copyright applications. So on the patent side, it's some technology created by DABUS because DABUS was written to create technology. DABUS was also created in a way so that it can also do artwork, two-dimensional artwork. And Thaler filed copyright applications for that artwork that DABUS created. In each case, Thaler in the application wrote the author for the copyright and the inventor of the patent as DABUS is not his own name. And so far, he's lost at the Copyright Office, he's lost at the Patent Office, he's lost in court. Although I'm not sure, he might have one case still pending.
I believe he still has one case pending, but this Thaler versus Vidal is on screen. Supreme Court declined to hear that case, so they've left the ruling alone that the rejection of those applications will stand.
this gets also to your point and your point as well. Why does it make a difference that you've written some software that creates something, and if it's not called AI, then you can get copyright and patent protection, copyright protection for artwork or for text and for other copyrightable works, patent protection for an invention. But if you write software that falls into the category of AI, whether it's using a large language model or some other model that is within AI technology, it doesn't get protection. That's where we are right now. Now, we can do rants about how perhaps the offices are not as comfortable with technology as they should be, and there's only 50 or 60 years of experience seeing that, where they've had these issues. And then, of course, the ultimate decider of these cases is the U.S. Supreme Court, which over the recent decades, regardless of whether it's, regardless of politics, regardless of anything else, has shown that they don't always get technology. There's been some very good technology decisions coming out of the U.S. Supreme Court, and some perhaps not so good, and some you kind of scratch your head a little bit. And some people who practice patent law have changed careers, in part because of some of these decisions. But you're getting right at the issue there.
Yeah, and one point to add that's worth noting when it comes to the Supreme Court handling issues of technology and intellectual property is that whatever preconceived notion anybody has about the politics of any particular justice goes out the window when you're dealing with these issues. There was a case involving trademarks just last year where it's the Warhol case or the Jack Daniels case. It was either a copyright case or a trademark case where the majority was written by Sotomayor, the dissent was written by Kagan, and there were footnotes between Sotomayor and Kagan going at it with each other. The Jack Daniels case, a trademark case from last year, going at it with each other about you're wrong, you're not well reasoned, you don't know what you're talking about, this is going to destroy XYZ. It seemed like any two opposite party Congress people fighting on the floor of Congress. So Supreme Court IP issues, it's a very different ballgame than most other issues.
So, and I should chime in here that in my forensics business, we had a case that I was working on involving also a logo. It was a beer company, I won't mention the name, but basically the person who created that, it was based on their original logo, and it was intended for that company's products. But then they didn't want to pay him. They had hired him to do this, but they didn't want to pay him because they were like, well, you didn't really do it. Well, wait, then why did you hire me? So it gets into all these different things, like when you're modifying things, how much of it is really your work, and should you be paid for that? In that case, that was really the employer didn't want to pay him, they had hired him.
Yeah, not surprising. Money seems to be a bit of a driver here. We're not sure.
Right. But we had to prove that it wasn't. He wasn't just scanning it and then whatever. He did actual work. So yeah, there's a whole variety of gray areas in there.
So has the higher courts given any guidance on like where the boundary is between, so Grammarly now has, as part of their products, they've got generative AI help you write what you're doing. And so the question then is, like, how much help is too much help for it to be copyrighted?
That's a great question. I mean, go back to this argument of the dawn. One of the interesting things there was that the artist, Pashnova, the AI created some of the artwork, and then Kashanova did some additional work on top of the AI. And one of the questions for the Copyright Office was that additional work by Kashanova enough for Kashanova to own those particular pieces of art? And in that case, the Copyright Office said the cleanup or the additional work that Kashanova did on top of the AI work did not change it dramatically enough to create rights by Kashanova in that artwork. With copyright, it's actually a fairly low bar, frankly. we talk about anything that's original to the artist or author. I'm calling it anything created as a work, whoever is creating it is called an author, even though it's and non-trivial. And they held that her additional work was still non-trivial and could not capture ownership of the artwork. They eventually did grant a copyright registration, but it wasn't in the artwork, it was in the text that had not been modified or generated using AI at all. Now, again, I'm not sure, maybe you're hearing this in my voice, and I'm not sure, I don't entirely agree with that. I think that at some point, what happens is if you have human working on even AI generated artwork, and the human does substantial work on top of that, if it's original and non-trivial, then those additions should be protected. And also fundamentally go back to the original issue, this goes back to your point. If AI is built by humans for use by humans, it's a tool used by humans, then there's no reason in my mind why copyright law should prohibit, or copyright office should prohibit registrations for AI generated works, and why the patent side of the Patent Trademark Office should refuse protection under patent law of AI generated. Now, and we can distinguish that from the monkey. We can distinguish it from this ethereal being. We can distinguish it from tides and other things that have allegedly created works, because ultimately, information technology is a human-made tool, and AI is a specific type of human-made tool. That's my rant. That's my argument. I'm sticking to it.
We're standing on it.
And we have some good questions here. Actually, gentleman in the back, I don't think I'm
Hey there. I'm also an artist myself. I have been met with many people who are artists, but also a lot with who are also, one of them is also a voice actor. They were concerned about how artificial intelligence is going to impact their jobs, and especially during the very important SAG-AFTRA strike and the WGA strike, which has said that many of the people who are in the unions, they were concerned of how generative AI could have a major impact, not only with their jobs, but also copyrights. And this one's very important because we, as not only tech folks, but also in arts, or familiar with arts or loved it with the arts, are worried if this is going to have an impact with them. But one of the biggest things I also want to ask is what implementations would we need to be aware of as artists to be aware of to protect the works from AI, but also with bigger things, like for example, with Sora now being able to make like a 60-second video of someone's prompt, which is crazy because now in the future someone could make a prompt, make an entire film that is artificially generated, or even using voice prints that someone may not have been authorized to use it and use it for a certain thing, like for a television program, whatever. I'm just curious about all that.
You're absolutely right, and it seems like you might have a copy of our slides because we're going to talk about all of these. I mean, these are some great segues into the next couple of topics. But to answer the question about the SAG-AFTRA strike, at the very least, you're absolutely right. Sora is for sure going to cause some disruption. Sora, for those who may not be aware, is OpenAI's text-to-video model. Check out some of the previews on OpenAI's website. The videos that it puts out are both incredible and terrifying at the same time. And when Tyler Perry, the filmmaker, saw some of these previews, he actually, from what I read, canceled the production project. He needs to see where the industry is going over the next few months and years. And so that's people who are now potentially losing work. That's projects that are potentially radically shifting in how they're going to be produced. So you're right, there are real disruptions for creative professionals that this technology is going to cause. I think it may be good to segue on to some of the next topics.
Yeah, let's hold these questions for a minute. There'll be plenty of time. So the next question we had was, what is the difference between generative AI and deep fakes? Is there even a difference? So go ahead with that.
Absolutely. And so to your question as well about the voice prints and the voice deepfake technology, great segue. As
great segue.
We're all likely aware by now, last year, there were all the headlines about the fake Drake song. Ghostwriter 977, an anonymous musician, started posting to streaming platforms and social media a song called Heart on My Sleeve, which was a collaboration between Drake and The Weeknd, fully AI generated using their voices. Neither Drake nor The Weeknd took part in this, and the only reason it was eventually pulled from the digital streaming platforms was not the voice rights themselves, but rather an unauthorized sample of Metro Boomin's producer tag that was taken from an official release. So there was a copyright issue there that led to the takedown of this song, but it was eventually re-released without the voice filters and without the sample, so that it could be eligible for the Grammys. Last year, the Recording Academy announced some eligibility requirements for AI generated or AI aided works for the Grammys. And so Ghostwriter re-released very quietly without any fanfare and without much press, Heart on My Sleeve to the digital streaming platforms for this purpose. Now, the way this works is actually quite simple. It doesn't take a whole lot of samples in order to build a model that can put together a fairly convincing replica of somebody's voice. And so that's something that we should all be careful of in our personal lives. Don't answer too many scam calls and give them too many samples of your own voice. But two, when it comes to in the creative world, there are real risks here if you're an artist or if you're a musician. And the other piece of this is from the legal side. Copyright law is actually not the right domain for voices and likenesses. There's a separate area called right of publicity law, which unfortunately there's no federal right of publicity at this point, which means that it's up to the states to have their own laws on this topic. Unfortunately, not all 50 states have a right of publicity. In the states where it does exist, it's very inconsistent. Sometimes it only exists for living individuals, and then it goes away once the person is deceased. In other states, there are timeframes for how long after a person's life the right persists. So there have been pushes for decades now for the right of publicity to be enacted at a federal level. And those rights, those pushes have really started to reach fever pitch in the last year or two since this has been going on with AI.
Long before AI, there was a case where Bette Midler sued the advertising agency Ford because Ford had gone to Midler and said, "We want you to sing over a commercial." And she said, "I appreciate the offer, but I don't want to sing over a car commercial." So the advertising agency then went to one of its backup singers and says, "Can you sound like Bette Midler?"
Whoa.
So everybody heard the commercial, and so was Bette Midler, and she sued and won.
Good.
So long before we had AI, we had people making using voiceovers that sounded voices that sounded like somebody else. Now, of course, it's much easier without having to find a backup singer.
And sound-alikes have sometimes been authorized. For example, Tom Hanks does the voice of Woody in the Toy Story series,
Yes.
Only in the movies. In any other media, video games, TV specials, it's his brother.
Really?
Tom Hanks has a brother who sounds sounds a lot like Tom, and the brother gets the Woody job for all of the non-film Toy Story media. So fun fact of the day.
That's
Question here.
I'm just curious, it may be too early to answer this, but you know how like in Delaware, there's no corporate tax.
Right.
There's different corporate taxes. So all these corporations go and, oh, I'm going to incorporate in Delaware.
Sure.
Are you seeing like a parallel, like if it's state by state, people wanting to work or generate work in certain states because there won't be protections? And like, I can almost see like there being a hub in city X, you know?
Yes, it's a good question. I mean, right now, not surprisingly, a lot of whether it's Hollywood or other industries, New York, Los Angeles, Nashville, Austin, California has a fairly strong law in favor of protecting artists. New York, not as much, but not so bad. Texas, probably not at all. And I don't know about Tennessee.
No,
on top of my head.
I'm not familiar with what the specific state laws are. There are some trackers online where you can see exactly where they are and how far they go.
But to your point, it wouldn't surprise me if some of these people who are generating might go to one state or another. In most cases, frankly, they go offshore.
For the district courts, right? So
Right,
there, some districts.
But they're worried about the U.S. courts.
So is that for creating content or showing that content in different states?
To the publicity law.
Often the right of publicity will go to where if that person is still alive, where that person is currently residing. And that's, so not surprisingly, when Miller sued, I forget where that time she was based in Los Angeles or New York, or both, but she had access to the right of publicity. Some years ago, I was contacted by the estate of a family of a famous actor who asked about right of publicity, and it turned out that she had passed away, I believe, in Maryland. And at that time, I looked at the law. Maryland did not have a right of publicity that survived the individual.
Oh,
So we couldn't bring a case then, because the law specifically that we're looking at said, where did that person pass away? And then that law applies. We're still waiting. That's also why we're still waiting for federal law eventually, or the states to eventually adopt a standardized law across the states. And we haven't seen much effort either by Congress or for a standardized law for the right of publicity. Copyright is entirely federal. Patent is entirely federal. States are not allowed to pass copyright laws. States are not allowed to pass patent laws. Trademark law, which is where a lot of this goes to also on, especially right of publicity, comes kind of not almost out of trademark. Is everywhere. It's common law, it's state law, it's federal law, and treaty and everything else all at once. So it gets interesting.
In the Enfish versus Microsoft case, basically.
You have to read that case now.
Oh, you're gonna talk about it?
And we might have.
Okay, well, the thing is, it's very, unless you can train, the computer in a way that shortcuts the way the computer works, you can't any longer get a patent on the software. Okay. However, with respect to the AI patents, yeah, I mean, there was a young lady who, came up with a method of diagnosing glioblastoma. Okay, and she put in a whole bunch of data from the slides, etc., and she got a printout and she got a patent on it. This seems to me to be a dichotomy with the other decision. And I'm wondering if somebody has a standard essential patent already on the AI learning technology, or there's still leeway to come up with new ideas.
Yeah, well, I personally, last question first, there's always room for more ideas. Whether you get a patent or not remains to be seen. There's a infamous quote from, I think, the 1880s, where somebody in the patent office said, everything's been invented, nothing's ever going to be, nothing else needs to be done anymore. And that quote has followed that person forever. Every so often it seems like everything has been invented. No. So I'm not too worried about new stuff being invented. The real issue is the issue of should the patent side of the patent trademark office, copyright office, should they grant protection under the law for anything generated by the AI? And you're exactly right, in that you can get a patent on technology created by a human that invents an AI, or on the patent side, a new invention that may be AI or an improvement on existing AI technology.
Right, improvement on existing AI.
The problem we have is then if you've created that AI itself creates.
But is there a current standard essential patent that you would have to clear?
I don't know. Off the top of my head, I don't know if it's a standard essential patent.
In order to come up with these new ideas, or do you have to clear someone?
With patent law, you always have to assume that you have to clear before you go out and bring it to market, right? Just because great minds think alike, there's a ton of patents out there. The good news is you can do some initial patent searching.
Yeah, if I'm going to create music with some of these things that we've seen now, do I have to clear somebody who's already got a patent on it? Is the question. Am I going to be sued if I come up with new music that I've created But am I at risk of being sued by some of these other patent holders?
One point that is at least going to make your last question a little bit easier to handle. Many of the AI companies who are building these platforms are offering indemnities to their users for any IP that comes out of the service. So that's to say that if you get sued because you used, say, I don't know, Stability. I don't know if Stability has an indemnity or not, but you know, Adobe is a great example. Adobe's generative AI in Photoshop. If you get sued for copyright or, I mean, potentially in patent, but any IP claim for that, Adobe will cover it. And many of these companies have put these policies out there, and it's a way of getting out ahead of the issue and making sure that when these issues get to court, they get to pick how that goes. They get to control it, they get to fund it, they get to give their choice of sophisticated, competent counsel, etc. Should we move on? I know we only have
let's move on. A few more slides, just a few more slides. So
We'll also be around to answer questions afterwards. So I'll be here later too.
So the next question was about stem splitting. Actually, one of our speakers mentioned in their talk. What is the guidance from the Copyright Office regarding this method?
Absolutely. So
interesting.
So stem splitting is interesting. It's been around for some number of years now, but it's gotten so much better in really the past 1.5 to 2 years. The way it works is you put an audio file into a program and it outputs stems of that audio for you that it generates. So it cleans up the vocals separate from the instrumental, and if you break down the instrumental into drums, bass, other instruments, guitars potentially separately. And you can use those stems to do whatever type of remixing, mashing up that you would like to do. This has plenty of application in the DJ world. This also has plenty of applications in the remix world, but most notably, this was used by the Beatles for their release last year. Never thought I would say that. The Beatles released a song last year, but sure enough, Now and Then was released in November of 2023 after many years. Yoko Ono had given some demo tapes that John Lennon had recorded to Paul and said he wanted this to be a Beatles song. You can work with it. You can do whatever you want with it. Wow. And it took many years for the technology to get to a point where the demo tape was workable. But when Paul and Ringo were working with Peter Jackson of the Rings fame on the Beatles documentary that came out a year or two ago, he basically let them know, look, there's new technology that you can use to clean up these demos and finish Now and Then. And that's exactly what they did. So the voice you hear on the final release is actually John Lennon's voice. Yeah. It's not a recreation. It's not an AI generated voice. It's just digitally cleaned and separated out from his demo tapes in 1977. And the Copyright Office's guidance, excuse me, on this type of technology is have at it. Do whatever you want using technology to aid in the creation of new creative works. The language on screen that you see highlighted, authors have long used such tools to create their works or to recast, transform, or adapt their expressive authorship. What that means is guitar pedals, digital audio workstation plugins, Photoshop, whatever you want to use. If it's stem splitting, if it's digital cleaning of audio, all good, have at it.
So then did Lennon or Yoko as his estate, did they get money for that particular
I'm not sure how that went. My assumption is yeah.
Wow.
Because the song is written by John Lennon. He's listed as the writer on the song.
He's
so
the writer.
My assumption is that the royalties for the writing are going to his estate.
So it was good of her to give the tapes, made her some more money.
It was a good investment many years later.
Very cool.
And because that's Lennon's voice, or considered to be Lennon's voice in that tape, because of the stem splitting, there's also performance rights there too.
Wow.
Which also generates money depending upon the contracts.
Wow, so the stem splitting is really important. This is great.
Yeah, and there are sites that you can use for free online. One that I've played around with is sounds.studio. I have no relationship to them. That's not, I'm just a user of their site, but they're free to use and it's really cool. They have a couple of free audio AI tools that you can mess around with. It's a lot of fun. Definitely give it a look if you're interested in this sort of thing.
Oh, cool. So our last question, but not the least, we can stay a little bit longer, other people can ask questions, was how can you protect your works and disallow AI adaptations?
Good question. One thing,
Tough one.
yeah, it's a tough one. Right now, if you're using AI to generate anything, text, music, artwork, what have you, you have to assume that the Copyright Office will not register anything. The courts will probably follow that for the short term. That means one of a couple of things. Certainly, if you don't use generative AI at all, you create something on your own, that's fine, human created, that'll be protected. By contrast, if you use GenAI to help build something, and then you make substantial changes to it, under copyright law, that may be protectable, again, to the extent that you modified whatever the AI has first output. Now, I am hopeful at some point that some of this law will change. I don't know whether or not it will. Let me put this in a historical context very, very briefly, which is I think it was around 63-64, the U.S. Supreme Court came out with a case called, I think it was Parker versus Fluke, also Gottschalk versus Benson. One of the first couple of cases involving information technology went to U.S. Supreme Court. One of them involved a translation table where they translated from the BCDIC encoding to EBCDIC encoding. And you don't recognize BCDIC and EBCDIC, you can ask the grandparents of ASCII. But the U.S. Supreme Court, I think correctly so, held that a translation from BCDIC to EBCDIC, which essentially is from one set of numbers,
Binary,
in binary, to a superset of the same numbers, is not sufficiently inventive to get a patent. Now, the patent office then made a mistake for the next 10 plus years and said, oh, we read these two cases to mean that software is nothing more than algorithms, and we're not going to protect software under patent law. And for a long time, they refused to even look at or do much review of software-based patents. So a case came out in the late 80s called Diamond versus Deere, where somebody took some software, attached it to a mold that's used to make tires. And essentially what they were doing was, rather than having a human being put a piece of rubber into a mold, close the mold, wait for the rubber to cook, and then open it up, and you have a mostly done tire. They put some probes into the mold, connected to a computer, and said, okay, we will run this algorithm that we know and see when it's time for the mold to open. And that's the invention. And the software, the use of the software makes that process better because we have fewer bad tires being made, because if you open the mold up too quickly or wait until too long, you get a bad tire and you can't use it, you got to start again. U.S. Supreme Court held in Diamond versus Deere that the use of software as part of this larger process was patentable. The patent office said, wait a minute here, you told us that software is not protectable. They're still playing catch up all these years later. They're still having problems understanding the technology, especially on the patent side, all these years later. And some of the more recent cases I could talk about, other people could talk about. I am hopeful that at some point, some of what we're seeing now coming out of the Copyright Office and out of the U.S. Patent and Trademark Office on the patent side will be changed, overturned, so that the use of an AI technology in and of itself does not make that output unprotectable by copyright or patent. That is a hope. That is my review of that. But that does not mean that the Copyright Office is listening to me, even though they did ask for comments not that long ago, more to any of the hundreds of other attorneys who are running on in this field. But this is where we're going currently. That it may change in the future.
How about how about a state infringing your patents? What if a state agency or state venture partners is infringing your patents?
It's harder right now because under current law, a sovereign state, if they infringe your patents or copyrights, they can't be sued unless they agree to be
No,
sued.
you can't sue them in the federal court, but can you sue them in the state court?
If the state will allow that, yes, it's a state by state issue right now. Because the states are considered to be sovereign entities and you can't sue them unless you allow that. So every time, we're working with a client that's selling or licensing software to, or doing some other work with a state entity such as a college, we have to have language in there that says that, yes, they can be sued and here's how we sue them.
It's time for one
And I think
more
Larry
question.
has-
But all of you can come up and talk to you guys afterwards.
So one thing was just a comment for earlier, OpenAI has an indemnity clause.
They
Very good.
do, that only extends to their enterprise tier.
Okay,
So they've given it a fancy brandable name called Copyright Shield. But unfortunately, you only have access to it if you're on their enterprise tier.
okay.
So.
And,
You have to pay for it.
Point.
You have to pay for it.
okay, another question. This image on this shirt was done by Bing Image Creator. In fact, that's the topic of the next talk.
He is the next speaker.
Very cool.
So is this shirt protected as a work?
How much additional processing did you do after the AI generated the image?
I took a template from Society6, I made a black background and then put the image on it and that's it.
Copyright Office might probably likely to refuse registration.
Okay,
And the courts will likely refuse protection should you end up in court over it.
good. I wanted to bring that up in this talk, not in my talk.
Fair enough. One closing point, historical perspective on the AI side is what Fred was saying. Historical perspective, if you're an artist, there have been lawsuits in the past about when artists' work is being infringed in mass. Napster is the perfect example. Napster was a peer-to-peer file sharing service that eventually was deemed to be wholesale copyright infringement by the courts. Enter iTunes. They made the process easier for people to get to the music. Now we have streaming as we know it today. So technology changes. We are not at the final version of whatever AI is going to be. And my assumption would be the same as Fred is hopeful that things will improve for AI generated works. Things will also improve for artists, where right now, yes, there is massive amounts of infringement going on. A personal opinion, taking the law all into account. I don't know that it will stay that way forever.
So put up your last slide so they can get your email addresses. And there we go. There were how you can contact.
The slide with our website, Wilftek, and if anyone can only be up there, they are. You're already up there.
Absolutely.
Feel free to download it. We also have another AI and other issues involving technology.
Fantastic.
And thank you, Rebecca.
Great.
Thank you. Yeah, bring it back.